All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is a time set for oral argument in our case, SA18-0121. Counsel, we have had an opportunity to review your filings. We have conferenced the case. We're familiar with the case. We held a stay hearing, of course, telephonically, so we have some feeling for the record. We've read the supplemental briefing as well. We appreciate that. We are here for oral argument on a fairly narrow but very, very important issue on jurisdiction. There have been a few sort of post-petition developments, particularly with respect to Alabama. But what we would like to do, and I understand we have the Petitioners Council, Guardian ad litem, Department of Child Safety, and then Mother's Council here as well. Both sides have 20 minutes. I hope that will not be a concern. If the petitioner wishes to reserve some time for rebuttal, you'll need to keep track of your own time, and I leave it to the tables as to how you wish to divvy up those 20 minutes. But we are familiar with the case. We'd encourage you to keep that in mind in your presentation today. And with that, let me start with this table. Mr. Johnson, you're going to proceed first. Very well.
Good afternoon. May it please the Court, Edward Johnson on behalf of the petitioners / adoptive parents / grandparents. We are here today on, as the Court stated, a pretty narrow issue. And I believe the narrow issue before the Court is whether or not the UCCJEA that does apply in this case would mean that the orders issued by the Honorable Judge Duncan are able to uphold the orders for adoption and the order terminating parental rights. We would submit to the Court that the Court in the Maricopa County Superior Court erred in the orders reversing the termination orders and the order of final adoption. We maintain that the UCCJEA does apply, was applicable, and that the Maricopa County Superior Court had jurisdiction over this case as it relates to the minor SB.
Can you cite us to the specific statute that gives you that authority?
Certainly. So there are a couple of exceptions, but I think the easiest one would be 25-1033, jurisdiction to modify determination, and specifically number 2, which states a court of this state or a court of the other state determines that the child's parents, and any person acting as a parent do not presently reside in the other state. I think clearly now it's pretty much uncontested that number 1 also applies, as Alabama post-petition did relinquish jurisdiction to Arizona.
Counsel, let me ask, there's comparable language in 1032 as well, as I think the briefs point out. But as I read the UCCJEA broadly, the thought is other than temporary emergency jurisdiction, which really isn't part of this case, it has as a concept that one and only one jurisdiction has our court has jurisdiction to issue family court orders unless an exception applies. And in 1032, which I have easily in front of me, it says the court, the first to issue an order has, and I believe 1033 contains comparable language, has exclusive continuing jurisdiction until something else happens. And in 1032A2, it's a court of Alabama or Arizona makes the call that you talked about, where the child and neither parent and nobody having custody or interest of the child resides in that forum state. The record presented, I don't think, supports any finding like that until at least, even arguably, until maybe January of this year. And what I know I struggle with is, it seems to me that your argument is that that finding can apply retroactively, can sort of look backwards. And I struggle to see how the UCCJEA supports that, and I have found no case supporting that. So help us on that.
Absolutely. And I share the court's comments, and I can tell you that I also looked and see that this is a matter of first impression. The case that I was hoping that would be helpful would be the Angel B, but that wasn't the issue before the court at that time.
And I'm familiar with Angel B.
Correct. As is Mr. Rosanelli, who argued that. So the one thing that I go back to, and I kept finding again and again, is when does the trial court have to make its decision based on? And I'll give you an example. If you're talking about a petition or a motion to terminate parental rights or a dependency petition, the court's obligated to look at the parent at the time of the actual proceeding, at the time of the severance action, at the time of the dependency adjudication trial, not 6 months before, not a year before. I would argue that the UCCJEA is the same, that we should argue that it's as we sit here today. I know in the conference held that Judge Duncan repeatedly said that we're going to go back as if we were back in January of 17 when this started. We're not doing it from today. We're going back of January of 17. Can't simply do that. I don't think it's that easy.
Wait a minute. You can't say that. You can't say that what happened in Alabama, the original orders, are just non-existent, right?
Agreed.
And clearly the child had moved to Arizona and had been in Arizona for a period of time.
Correct.
And if you want to apply the 6-month consideration for
Home state.
I'm sorry?
The home state?
Yes. Clearly you can look at that, but does the fact that that's the home state then automatically undo what happened in Alabama?
I don't think so, Judge Jones. I still think, as Judge Lemon pointed out, you still have to have that conference. But I think we have a problem is on page 10 of, I believe it's Appendix 2 from the mother in her brief. Judge Conaway says that he was going to keep jurisdiction at that time. But he says, and I quote, "Unless there was some extraordinary circumstance that was presented to me and I was unaware that the mother had relocated," end quote. Father dying is certainly an extraordinary circumstance that would have, I believe, affected his decision.
But don't we need Judge Conaway to say that?
Well, and I think he ultimately does when he's fully briefed on all the facts after the petition and after our telephonic conference when he took the matter. He repeatedly states in the conference that he's open to an inconvenient forum argument. He's open to somebody giving him some more facts, but he just doesn't have it before him. And Judge Duncan repeatedly says, well, we're not doing that today. We're here as if we were here in January of 17. And I think Judge Conaway is reaching out saying, give me facts. I don't know the facts. I haven't touched this case in a while. The facts before me are really stale, so I don't know anything. So barring some extraordinary circumstance, yeah, I would have kept jurisdiction. So I think had Judge Conaway had the courtesy of getting the facts, as the GAL at the time was trying to give to him but was shut down, I think his outcome would have been different. I think the results of his would have been different.
But his outcome earlier this year, right? Not, in, say, March of 17 or in the fall of 16.
And that we don't know. Obviously, father passes away January of 17, so it would have had to been after that.
Are you aware of any cases applying any aspect of the UCCJEA that does kind of the retroactivity approach that you're asking this court to do here?
Frankly, not that I could find on either side.
I think we interrupted you.
No, you're fine. So that's our belief. I believe that Judge Conaway is really trying to do the right thing. I think this court is aware of how important matters involving children are to the court. There's a priority given to the juvenile court. There's a priority in this court given to all matters pertaining to juvenile court per your administration order. So we simply ask that this court reinstate the orders terminating parental rights as it related to this child, and also reinstate the order of adoption. I know we didn't touch upon it, but I couldn't, in my perusing of the record, and mind you, I wasn't the adoption attorney for the family. I came on just for the appellate aspect. But I couldn't find anything that dismissed the actual dependency other than Judge Duncan's final order. So I didn't see anything where she says she reverses her dependency findings. I saw she reversed the termination, reversed the adoption. I didn't see anything about the dependency. So we would submit to the court, if she's going to dismiss the dependency in just normal course, not do a jurisdictional defect, that she has to consider the best interest of the child. And the last thing that I'll submit to the court is we do think, even given the retroactive issue that we may have, we do think there was a problem with the UCCJEA in one respect. And that is on 251010, the communication between courts. And that clearly states that Judge Duncan has a discretion to hold the conference however she deems appropriate and necessary with Judge Conaway, as schedules permit. But it also says that parties may be allowed to participate, and if the parties are not able to participate in the communication, they must be given the opportunity to present facts and legal arguments before a decision on jurisdiction is made. Ms. Preciado, the former attorney, the adoption attorney, was not present at that. If you read the attachment number 2, it's mentioned in there several times that Ms. Preciado was not present. Yet at the end of that hearing, Judge Duncan makes her findings. And the following day, she makes her orders again. With Ms. Preciado present, Ms. Preciado tries to interject, and Judge Duncan won't let her. We feel that's a violation. We feel that she was obligated to at least be given an opportunity to present facts for her client and wasn't allowed to do so.
What would those facts have looked like that might be dispositive here?
Judge, we think what it might have looked like would have been just the fact that the Alabama court did not have all the final information, didn't have, based on the hearing prior. She obviously would have had to have known what happened in that hearing, and the rule makes it pretty clear that she would have to be given an opportunity to have either the transcript or recording. So I think that would have given her an opportunity to at least try to flesh that out with Judge Duncan, but she wasn't given that chance.
How would that be outcome determinative if, in fact, the UCCJEA doesn't allow this sort of retroactivity application?
Well, I think it would have possibly determined the outcome, because I think then maybe there's a chance that Arizona, I don't believe, needs Judge Conaway's permission to exercise jurisdiction. I think when you read exception number 2, it says that she can make that finding.
And I think I'm with you there, but again, at least, and I'm looking at 1032, which has comparable language, but it says, as I read it, Alabama has exclusive continuing jurisdiction until Arizona makes a contrary ruling. And so what you're talking about were hearings that, as I recall, were in April or May of this year.
May 9th, correct.
Right, okay.
And I'm going to let Mr. Rosanelli take over from
Very
me.
well, thank you.
Thank you, judges.
Mr. Rosanelli.
Good morning, judges. May it please the court, my name is Robert Rosanelli. I'm the attorney, or GAL, I'm not quite sure, but I represent the interests of the minor child, who we affectionately know as SB. I represent the child, agree with the petitioner's position in this case. I believe that Judge Duncan erred in not finding that the exception found in 251033-2 applied. And I thought really this was a simple case, but as I got into it a little more, I think it's a little more complicated than that. And I do agree that there's not a lot of case law on these two exceptions. When I looked at this, I saw that, in my opinion, I saw that if either one of these following exceptions apply, then this court could take jurisdiction, okay? Which, of course, the court declined to do so. And I believe that this court can make a separate, independent determination on these things, at least with regard to number 2, aside from any determination made by Alabama. Because, of course, under 2 it says a court of this state or a court of the other state determines that the child, the parents, and any person acting as a parent do not presently reside in the other state. So conceivably, and I don't know, we wouldn't want this to happen, but conceivably Alabama could make a separate determination. And they could make a determination that some of these interested parties do live in Alabama. And our court could make a separate and different determination. And I don't know what to say about that, but this UCCJEA is written allows for that to occur. And really, I think Judge Duncan should have made that separate determination. And I don't know really that the Alabama judge made the determination about the people not living there. They seem to really just not want to divest jurisdiction, not concede that this is a more appropriate forum until he did about 2 or 3 weeks later. And I'm not sure why. Go ahead, I'm sorry.
Try and keep my thoughts.
Yeah.
Ultimately, he did say,
correct,
no one continues to reside in this jurisdiction.
Absolutely.
Okay, thank
you.
He
did. He did that in late May, and May 31st. Okay. And at that time, as we know, he made an order that The court determines that the Circuit Court of Henry County, Alabama is currently an inconvenient forum, and that the Maricopa County Family Court, of course we're in the juvenile court, but that's okay, of Arizona is a more appropriate forum for further proceedings. We made that finding about 3 weeks or 2 weeks after the UCC JEA conference. So now I don't know what happened back in Alabama. I don't have that whole file. It almost looks like he reconsidered his earlier determination. That's because it was so close in time. And there's nothing that occurred other than a passage of 2 to 3 weeks. Nothing significant, to my knowledge, occurred in those weeks in May. And so in early May, he confers with our court, and he doesn't want to give up jurisdiction or feels it's not appropriate to give up jurisdiction. But then he seems to have reconsidered. And that's the only way it makes sense to me.
Although it seems to me, and I'm not sure, I want to ask you a follow-up as to whether what impact this has on what we're asked to decide today, but forum nonconvenience and disavowing jurisdiction are somewhat different things.
Right.
And that's a different portion of the UCCJEA.
Right.
So perhaps that might explain it. But let's say instead, in the earlier hearing in May, the Alabama court said, you're right, I'm ceding jurisdiction to Arizona. Does that resolve the issue from your perspective? Because it seems to me we still have that exclusive continuing jurisdiction until that finding is made, and I struggle with that.
Well, I see what you're saying. I don't really know the answer to that, but I see what you're saying. It's a good point. So until it's brought to the court's attention.
With this concept that you have one court that can issue orders absent temporary emergency jurisdiction, which really isn't applicable here, not two, to avoid the competition that predated the UCCJEA.
Right. It would have been better had the court made a determination that Alabama did not have, or Alabama was not the most convenient forum at the time of the initiation of the Arizona proceedings in early 17. That would have made it all so much clearer.
We wouldn't be here.
I would hope not.
If that happened. But that didn't happen.
No, it didn't happen. Now, whether that judge was requested to make that determination, I don't know. I wasn't in the juvenile court, and certainly not in the court of Alabama. And also, we don't know what that judge in Alabama was requested to make, exactly what finding he was requested to make in late May. Okay, whether, don't know. Okay, did he really intend to say something else? Of course, we can't really speculate about that. We'd go crazy doing that. It would be not appropriate to be speculating. We all know that. So I don't know what he intended to say, but he did in early May decide that Alabama was the most appropriate place. We know that. And I assume that applied to early 17 as well in his mind, but I don't know that. We do have conflicting things to hear, though. Okay, so Arizona could have said, thanks a lot, Judge, but we, Arizona court, decide that this exception number 2 applies, that no one lived there. No one lived there now. No one lived there back in early 17 when the dependency was filed, and ultimately when the severance was filed, ultimately when the adoption was filed. So we could have had that. And I think Judge Duncan erred in not making that determination. So with regard, or regardless of number 1 and retroactivity, which we could all chat about really for hours, I'm sure, but irregardless of that, I think number 2, that exception applied. And Judge Duncan should have made that finding that this court, Arizona, had jurisdiction back in early 17 because nobody lived back in Alabama at that time.
Did the petitioner or you ask Judge Duncan to make that finding?
I don't know. I wasn't involved in the trial court. I do not know. I've read the file, but I don't know if that was really clearly requested. It would have been great had it been requested.
And if it hadn't been requested, how can Judge Duncan be faulted for not making that finding?
Well, I understand. So don't expect the judge to do what somebody has been asking to do. What this court could do would be to return this to either court, well, certainly to our court, to conduct further proceedings and to answer the question.
Define the question, please.
Okay, so that question would have been, would exception number under 25-1033-2 apply? And would have applied back in early 17 when all this juvenile court action began. And the exception, so make a finding about whether any of these parties, mother, father, child, lived back in Alabama, or whether this exception applied back in early 17. Really, that was the entire question, the whole case, and no judges really answered that.
Debate that one of the necessary parties to these proceedings at that point continued to reside in Alabama?
I don't think so.
I guess you seem to be putting a couple of different parts on a completely different car here for me. I'm not sure that they fit. I don't know how you go back into that environment and say, well, since an aunt was still living here, or since, that we're going to say X.
Okay.
It's not even part of the discussion, is it?
Well, when juvenile court proceedings occur, jurisdictional findings are made, okay, as is true in other courts. So the court had to find that the court had jurisdiction back in early 17. And so jurisdiction was accepted by this court at that time, and then this was all brought to a head by Mom after the fact. And then the court could have answered the question. The court could have said, we did take jurisdiction back then, and we meant to do that, and this is why this exception would have applied, had we even known that this was an issue. That could have been raised, and it still could be raised, and the juvenile court still could answer that question.
Because how does that work if Alabama still believes, at least at that point, believed it was the home state mother, and correct me if I have the timeline right, but mother came back to Alabama to change custody once she learned that the father had died. So doesn't Alabama, at that point, did Alabama still have a dog in the fight, so to speak?
Well, Alabama certainly was the place to go. Could have been the place to go to at that time, but I don't know that Mom went in and said, by the way, I don't live here anymore, and Dad's deceased or doesn't live here anymore, and the child's gone. We don't know if Mom went in and told the court that. And the pleadings that Mom filed here in the juvenile court, including the motion to set aside and revised motion to set aside, she didn't reveal where she was living. It just is a sort of standard motion without any comment about where she lived. So I don't know that the Alabama court really had the full picture, and I don't think Mom told the Alabama court that an adoption had occurred, and also the grandparents, otherwise the grandparents should have been served, but I don't think that occurred. So I don't know what happened back there, I don't know what happened back in Alabama, but Alabama, this UCCJEA leaves the door open, I think, to have a result that they really don't want, which is conflicts, okay? And I know that's a hard sell, but I think that's not written well enough to close the door on that. Alabama could say, we're still the most convenient forum. Arizona could find that nobody lives back there, and this exception applies, and I'm not sure that Arizona couldn't just say, we're going to do this. We've got jurisdiction. The case was here, and we've already litigated these things, and it was appropriate for us to do so. And that's really where I think Judge Duncan could have done that. But again, I looked for cases to try to find, did this ever occur at any place, and how was that resolved? And honestly, I couldn't find that, because nobody really wants two states fighting over the child. That's totally against the purpose of this statute. I know that, but I think that result still can happen. I just don't see where it's happened at the appellate level, other than today.
Mr. Rosanelli, thank you. Your time.
Thanks very much. Appreciate it.
Counsel, are you okay if we give petitioner? We'll give petitioner 90 seconds for rebuttal. It sounds like nothing, and I was going to look to the Williams, but that would be redundant. So, Ms. Williams, you may proceed.
Thank you, Your Honor. May it please the Court, my name is Dawn Williams, and I represent the Department of Child Safety, and I'll be arguing for our side of the case today. I think the most important facts here aren't in dispute, and that's that Alabama had jurisdiction in 2016 to make an initial child custody determination, and under the UCCJEA, once they made that determination, they had exclusive continuing jurisdiction over it until one of three findings was made. Two of those findings could only be made by Alabama, one by Arizona. The fact is, none of those findings were made prior to the juvenile court here entering the dependency, termination, or adoption orders. So that's where the problem is that those findings have to be made beforehand. It doesn't matter what the facts would have been at that time, because no evidence was presented at that time. The court didn't make a finding.
So, if someone had asked Judge Duncan to make the finding under 2510 33, do you agree that he could that if he would have found jurisdiction at that point, that he could do that regardless of what, regardless of what the Alabama court did?
Yes and no. I think had Judge Duncan made that inquiry in January when the dependency petition was filed, she could not have made that order because at that point Mother still lived in Alabama. It wasn't until March of that year that Mother relocated to Tennessee. So it wasn't until after March that Arizona had the authority under 1033 or 1032 to say the child and a parent, no parent, nobody lives in Alabama anymore. And so it wasn't until after March that the court could have made that finding. But I agree that had the juvenile court in Arizona had the authority to make that finding after March, and we wouldn't be here today had the court done so. The problem is that finding wasn't made. And if you look at Melgar v. Campo, paragraph 18, this court found that the finding about under subsection 1 that no one has any significant connection to the state has to be made before modifying the order. And I think it's analogous here.
So it doesn't matter that the facts supporting such a finding would have existed in March. It's the fact that the finding wasn't made in March.
That's correct.
That's determined.
Yes, that's what has to happen to give jurisdiction to the Arizona court. The Arizona court never properly obtained jurisdiction to enter the orders that it entered. And I agree with Mr. Rosanelli that I also couldn't find a specific order where the judge vacated the earlier dependency order, although the judge did dismiss the dependency finding. But it's the department's position that that order, like the other two, was void for lack of jurisdiction because the juvenile court had only temporary emergency jurisdiction at that point.
You've heard me ask Mr. Johnson especially some questions about whether there's any case law construing this specific aspect of the UCC-JEA. Are you familiar with any?
I'm not. As I mentioned, the Melgar v. Campo deals with the subsection number 1. I think it's analogous. Angel B, of course, indicated that the determination regarding the continuing jurisdiction has to be made on the record, and again, that wasn't done here. But that's the closest I could find to anything addressing this specific narrow issue. And I think that the Alabama court was clear that during the UCC-JEA conference that he needed more information, and the fact is that he was presented that information. Both the grandparents and the mother filed pleadings in Alabama in the open case there, and it was after that that the court in Alabama was able to make its determination regarding a convenient forum. So I think that the fact of the matter is the path is clear now for this case to proceed in Arizona, but it needs to proceed from the beginning. We need to start with a dependency adjudication, and if someone pursues a termination, go through the whole process.
As a point of clarification, it's not. It is a side issue, not an issue that we're asked to address. Isn't there a petition filed currently for severance? Perhaps I misrecall that.
There had been a renewed dependency petition filed by the children's guardian ad litem in the trial court, but the court dismissed that.
Okay.
So I think it would depend on how this court responds. If this court declines jurisdiction, we would probably file a new dependency petition since the juvenile court did dismiss the dependency action. If this court remands, then of course I think that dependency action would still be live if this court vacates the order dismissing the dependency. But I don't think the court can proceed as though the dependency adjudication, the termination order, or the adoption order are still in existence. I think they are all still void.
The Duncan orders, so we're clear.
Yes, correct.
Including the dependency to the extent there's lack of clarity on that.
Yes.
Let me ask as well, and I'll ask in the rebuttal time, are the child's needs being met currently?
Yes, the child remains with the grandparents, and the mother has agreed to allow that to continue until this matter resolves. So,
and I recall that, a flavor of that from the stay hearing, and
correct.
I respect and appreciate that.
And it's the department's position that in the event this is revived and we go back, that we would look at the mother to see what, because there hasn't been communication in some time, to see what the appropriate dependency action would be.
Thank you. Questions?
Thank you, Your Honors.
Mr. Johnson, rebuttal. And let me start, even before your time starts, with from your perspective, if the child's needs are being met.
Thank you. Absolutely. And just a point of clarification, the child's resided in the same home pretty much since August of 14 when she's been there. Dad lived there with his parents. So this has been her home for pretty much 4 out of her 5 years of her life.
That's the flavor that I got.
Yes, absolutely. One thing I think, Judge Jones, you asked a question about, was Judge Duncan ever asked to make the finding regarding exception number 2?
One of us certainly.
Yeah, so Ms. Preciado actually did bring that up in her UCC JEA briefing, and the department attached that in their appendix. Ms. Williams actually put everybody's UCC JEA briefing in there. And Ms. Preciado actually does bring that up in there. She does say that number 2 applies because everybody's gone. When everybody was gone, we really don't know. We know that Mom admits as of March of 17 she no longer lived there. That time is significant from a historical perspective because Ms. Bergwand filed the private severance petition in March of 17.
The state argues with some force that jurisdiction, in a sense, is not self-executing. Jurisdiction just doesn't kind of settle on the court. The court has to make the appropriate finding. So even if the facts supported a finding of jurisdiction, if the court doesn't invoke jurisdiction under the statute, then our court wouldn't have jurisdiction.
Right, and I think you can't have it both ways. And what I mean by that is Judge Duncan makes it a point to go back and say, well, as of January 17, if we had this conversation January 17, I think then if she has that conversation as of March of 17, the facts come to Arizona. The facts uncontested, Mom's no longer there. Number 2 applies. Arizona can take jurisdiction. And just lastly, he did, Judge Conaway twice reconsidered. Once he gave Mom custody. That was brought before him again. He stayed that order. And then again, as Mr. Rosanelli pointed out, the whole jurisdictional aspect, he did do that. So we thank you for your time, and we look forward to your decision.
Counsel, thank you. We will take this matter under advisement. We'll issue a written ruling in due course. I want to thank counsel for their careful and helpful presentation today, as well as your briefing. It's you've given us much to think about, and we understand the gravity of this case. Thank you.